Hello everyone. Welcome to our video series of Lakshmikant Indian Polity for UPSC CSC, SSC and Banking Examination. Today is the 7th video. In this video, we will be discussing about the fundamental rights. Because the fundamental rights is a very big chapter. So we will be discussing the basics of fundamental rights in today's video. This is part 1 of the video. Part 2 of the video will be coming soon. In that, we will be discussing the current implication and in detail every fundamental right. So for any queries, you can email us at info@GyanMimansa.com. This is our email ID. And you can also join our Telegram channel, the link to which will be provided. One announcement, we have started free answer writing practice, daily answer writing practice. So you can join our Telegram channel and email me with your details at info@GyanMimansa.com. And you can join it. It is free for everyone. You will get evaluated copies. You will get one question every day. You will get the evaluated copies, and also there may be some discussion sessions. We will be planning to have some live discussion session and doubt clearing sessions where you can also talk about any other kind of doubts regarding the prelims, mains, or any UPSC related queries you can get resolved there. So let's start today's video. So fundamental rights. Fundamental rights, what are fundamental rights? Fundamental rights are being taken from the United States American Constitution, US Constitution, from their Bill of Rights. Fundamental rights are the rights which are fundamental to every being within a country, and they are promoting political democracy. It is not about economic and social democracy, but political democracy provided by the politics of India, provided by the Constitution of India. It is provided in the Part 3 of Constitution under Article 12 to 35, also known as Magna Carta of India. There are 7 types of fundamental rights available to any Indian, out of which right to property. This has been repealed by 44th Constitutional Amendment Act of 1978. It is no longer a fundamental right. So there are 6 rights currently available, 6 categories of rights currently available to every citizen in India. First is right to equality, Article 14 to Article 18. Second is right to freedom, Articles 19 to 22. Right against exploitation, Article 23 and 24. Right to freedom of religion, Article 25 to 28. Cultural and educational right, Article 29 and 30. And right to constitutional remedy, Article 32. So you need to know various categories of rights: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational right, and right to constitutional remedy. If you remember this, you can remember the sequence of Article 14 to 18, 19 to 22, 23, 24, sorry, 25 to 28, 29, 30, and 32. Apart from this and this, there are 4 articles in each category. 442, 421. If you can remember this, so you can remember the 6 rights which are available within their broad sense, and then now we will discuss each of these rights separately. So first, before the fundamental rights itself, there are 2 articles, Article 12 and 13. What these articles will be saying under the heading fundamental right. So Article 12 states the definition of the state. So what is included in the definition of state? Government and Parliament of India, government and state legislature, all local authorities. That means the central government, the state government, and the local self-government body, means urban local bodies and Panchayati Raj institutions. Along with this, all statutory and non-statutory authorities under the Constitution of India, under any law of Parliament or state government, or any other bylaws, any body that is been, authority that is been created by the state under any law or without any law, all are considered as state under Article 12. There are few Supreme Court judgment, those we will be discussing in our upcoming sessions. So what are the features of fundamental rights? So some of the fundamental rights are available to citizens only, while others are available to all, in citizens and aliens both. Yesterday, in our citizenship topic, we have talked about what are citizens and what are aliens. They are not absolute but qualified. That means there may be some reasonable restriction. All of them are available against arbitrary action of either state, any authority, or even private personal. If some private person is also acting arbitrarily, so they can be available. Some of them are negative in character, some of them are positive. That means some of them are giving the burden on government. For example, equality before law. That is, it is a little negative concept, negative in character, because equality before law means government cannot discriminate. So it is negative burden on government that they cannot do something. Similarly, some are positive. For example, equal protection of law. So according to this, all are equally protected by the law. So here government has to do something, or here government cannot do something. So this is about the equality before law and equal protection of law. This is how negative and positive are in nature, some of the fundamental rights. They are justiciable, means they are anyone can move to courts if they are being violated. They are not sacrosanct and or permanent. They are not permanent. They can be suspended or amended, and they can be suspended during national emergency, as we have spoken under Article 356. We will be talking about this in Article 356, emergency chapter. So now, what is Article 13? We have talked about Article 12. Article 12 is the definition of the state. Article 13 states law inconsistent with fundamental rights. That means if any law is there which is not inconsistent with fundamental right, then what happens? So Article 13 states that all laws which are inconsistent with or in derogation of any fundamental right shall be void. This is what Article 13 says. So from this, the concept of judicial review came. What is judicial review? Judicial review is the power of Supreme Court and High Court to review any law if they are in violation with fundamental rights or not. So that is judicial review. Or if they are in violation with any constitutional provision, existing constitutional provision or not, that is we call as judicial review. So under Article 32, within the fundamental rights itself, and under Article 226, the power of judicial review has been conferred to Supreme Court and High Courts under Article 32 and 226 respectively. So any law which can be void can be permanent law enacted by Parliament or state legislature, can be challenged of being violative of fundamental rights, any temporary law like ordinances, any statutory instrument like delegated legislation. We will talk about what is delegated legislation in our parliamentary chapter, but for a smaller talk, we want for a brief explanation. So delegated legislation is something, for example, a law is being passed by parliament, but it is not being in that much detail how it is going to be operative. So it is passed on to the executives, and they form the bylaws and other connecting laws. So that is called as delegated legislation. So any delegated legislation also within the law also is violative of fundamental rights. So that can be reviewed by the judiciary, and any other law apart from this, any other kind of law, if it is even it is a natural law, if it is some customary law, then anything can be challenged on being violative of fundamental rights. This is stated in Article 13. So here are some other doctrine of eclipse. Okay, so we will be talking about that again in the fundamental rights advanced chapter. Then first is the right to equality, Article 14 till Article 18. First, Article 14 is equality before law and equal protection of laws. I have explained a little. That means state shall not deny any person equality before law or equal protection of law within its territory. That means all people, every citizen in the eyes of the state is equal. There cannot be privileges to any citizen based on their citizenship of India. So that is fundamental. And then equal protection of laws. So again, the parliament should protect each and everyone with equal. So parliament cannot, or the state cannot give any privileges to anyone, and they have to protect everyone equally. That means they can take affirmative action to raise some. Next, second, Article 15 is prohibition of discrimination on certain grounds. So Article 15 states that state shall not discriminate against any citizen on the grounds of religion, race, caste, sex, or place of birth only. So this religion, race, caste, sex, or place of birth, these are 5 things based on which the state cannot discriminate against anyone. That means there is the word written only. That means there are few other things based on which state can discriminate. And we can also talk about the positive discrimination as suggested under the reservation and of OBCs, EWS, SC, ST, women and disabled, differently abled, etc. Women, child, differently abled. So government or the state can make special provision. This is not covered under non-discrimination. This is positive form of discrimination. And here the positive discrimination is allowed. Again, we will be discussing the nitty-gritties of each and every article in our separate videos. I'll be making small video on every article, Article 14, Article 15, Article 16, whichever articles are important, including Article 12, what are the Supreme Court observations, because this chapter is very important. So I'll try to bring 7 minutes, small videos where I can explain each and every fundamental right in a little more detail. Moving ahead, the third part, that is Article 16, is equality of opportunity in public employment. Equality of opportunity for all citizens in matters of employment and appointment of any office. Again, reservation is an exception. Apart from that, all are equal. That means, again, the affirmative action is not denied by the Constitution. The state can take affirmative action to uplift the poor, uplift socially, economically, educationally backward. For example, recent economical weaker section, 10% reservation. Then Article 17 states there is abolition of untouchability. That means, although untouchability is not defined in the Supreme Court, there are various acts enacted by the Parliament, including Civil Rights Act 1955, SC/STs Atrocities Act, etc. These are enacted to abolish the untouchability in India. And Article then 5th is that is Article 18 is the abolition of titles. So 14 to 18 we can repeat once. 14 is right to equality, equality before law and equal protection of law. 15 is prohibition of discrimination on certain grounds. 16 is equality of opportunity in public employment. 17 is abolition of untouchability, and 18 is abolition of titles. Next, second set of rights are right to freedom, Article 19 to 22. Under Article 19, there are 6 type of freedom available to every citizen of India. This include freedom of speech and expression, freedom of assembly, to assemble peacefully and without arms, to form association or unions or cooperative societies, freedom to move freely throughout the territory of India, freedom to reside and settle in any part of the territory of India, and freedom to practice any profession or to carry out any occupation, trade, and business. Here is speech and expression, assembly, as forming of associations, and to free movement, free residency, and free profession. These are 6 fundamental rights within one right, that is Article 19. Moving ahead, Article 20, protection in respect of conviction for offenses. So Article 20 states that there is protection available with every citizen against arbitrary or excessive punishment to accused person, citizen, or foreigner, or even any legal person. What is legal person? We'll again be talking. So in this, no ex post facto law. What does this mean? If, for example, today is 10th April 2022. So if anyone commits a crime today, and for that crime, if today's punishment stipulated is for 1 year, and at a later stage, for example, on 15th of April, there will be an amendment where this Parliament is stipulating 2 years of imprisonment for the same crime, but this cannot be given to this person because it has been committed before. So this means no ex post facto law, but this is applicable in case of civil matters only, not in the criminal matters. Again, we will be talking about civil and criminal matters in detail. No double jeopardy means no one can be punished for the same crime twice. That is called as no double jeopardy. No self-incrimination. So no one can be compelled to give statement against themselves or confess their crime. So no one can be compelled to do that. That is no self-incrimination. Next, protection, Article 21 is protection of life and personal liberty. No person shall be deprived of his life or personal law except established by law. So that means anyone's life and personal liberty cannot be taken away except anything established by law, for example, capital punishment. So this is a very broad law, broad one, and a lot of cases are there. Recent Puttaswamy privacy judgment was also under Article 21. So again, there will be wider discussion on this in other videos. Then right to education under Article 21A, 86th Constitutional Amendment Act, it was inserted. Okay. Then next is protection against arrest and detention under Article 22. So there can be two types of detention, punitive detention and preventive detention under Article 22. So there cannot be any arbitrary arrest or detention. And in any of the violation of these fundamental rights, there can be writ petition filed under Article 32. We'll be talking about Article 32 today itself. Next, the third set of rights are the right against exploitation. There are two rights under exploitation, Article 23 and Article 24. Article 23 prohibits traffic in human beings, begar, forced labor, or beggary. Okay, so trafficking in human being. Human trafficking means to sell human or to, for example, prostitution, to compel someone for prostitution, etc. These are called as trafficking. So it is prohibited. It is a fundamental right of any human being in India that they cannot be trafficked. They cannot be sold. Article 24, prohibition of employment of children in factories. For example, prohibition of the employment of children below the age of 14 years. So here are also some exceptions, and there are a lot of laws regarding this. We will be talking about them separately. Next, the fourth set of rights are right to freedom of religion. So Article 25. All persons are equally entitled to freedom of conscience and right to freely profess, practice, and propagate their religion. That is, here are four types of freedom: freedom of conscience, freedom to profess, freedom to practice and propagate. Whatever they want, they can feel about any religion, their inner conscience. They can profess any religion, they can practice any religion, they can talk about any religion, they can practice religious practices, for example, prayer, whatever their method is, and they can propagate their religion. But here is no right to conversion. So forceful conversion is not allowed here. So they can propagate. You can propagate your religion, but you cannot compel anyone or force anyone to change their religion. That is under Article 25. Article 26, freedom to manage religious affairs. So Article 25 is individual right. Article 26 is the right to the religious denomination. Okay, it is the right provided to religious denomination, and it is a collective right. So there is a conflict between Article 25 and 26. Individual right versus collective right in Sabrimala case. So Sabrimala case will be discussed separately in a current affairs videos. So we will be soon bringing current affairs videos also. Next, freedom from taxation for promotion of religion. So no person shall be compelled to pay any taxes for promotion or maintenance of any particular religion or religious denomination. So no one throughout the country can be compelled to promote or to maintain any religious institution, anything, right? Even government or non-government. So government can also not compel, the state cannot compel, and also any private person cannot compel anyone. to pay taxes for maintaining any religion. Next, freedom from attending religious instructions. So, no religious instruction shall be provided in any educational institution wholly maintained out of state funds, wholly or even partial. Anything, any educational institution maintained by the state, there is no religious instructions can be provided, shall be provided there in any form. So these were the fourth set of the rights. Then the fifth set include cultural and educational rights. There are again two rights, Article 29 and 23, provided to cultural and educational minorities basically. First is protection of interest of the minorities. Article 29, protection to both religious minorities as well as linguistic minorities. So here are two types of minorities are described in this article, religious and linguistic. So they are this article protects both kind of minorities, and they can they can promote their own interests throughout the country. For example, educational institutes, minority educational institutes, etc. Then Article 30 talks about establishment and administration of educational institutes by the minorities. So minority institutions are of three types. That's one, 6 recognition and aid from the state. Second, those 6 only recognition but no aid. And third are neither aid nor recognition. Okay, these are three types of minority educational institution. So till now we have talked about Article 12, 13, then 14 to 18 equality, 19 to 22 freedom, 23 to 24 against exploitation, 25 to 28 religion, 29 to 30 minority cultural and educational rights. So moving ahead, Article 32. This article also called as the heart and soul of Indian Constitution by Dr. B.R. Ambedkar. This is right to constitutional amendment. That means if there is violation of constitutional right, sorry, fundamental rights, so any aggrieved person can move to the Supreme Court directly under Article 32 for with a writ petition. So Article 32 states right to remedies for enforcement of fundamental rights of an aggrieved citizen. So this is a basic feature of the Constitution. It cannot be abridged or taken away by any amendment, and violation of fundamental right is cannot be done within India. So writs are there. So you can directly move to the Supreme Court if there is violation of fundamental right. Under Article 32, you don't have to go through the hierarchy of the courts. And you can also go to the Supreme High Court under Article 226 to issue writs. But in this case, Supreme Court is bound to issue some judgment, issue the writs if there is violation of article. However, High Court can deny. So it is a compulsion because it is a fundamental right, 32, but 226 is not a fundamental right. So there are 5 types of writs available: habeas corpus, mandamus, prohibition, certiorari, quo warranto. We'll be talking about these writs in the judiciary chapter. Then there are some special rights or some special provisions under Article 33, 34, 35. What are these provisions? Article 33, Armed Forces and Fundamental Rights. So Article 33 empowers Parliament to restrict fundamental rights of armed forces, paramilitary forces, and police forces, etc. So because this is for the security of India. So why can they restrict fundamental rights? To ensure proper discharge of their duties and to maintain the discipline. So few of the rights can be taken away by the parliaments for the personnel within the armed forces, paramilitary forces, police forces, basically the security related. Then Article 34, martial law and fundamental rights. If there is martial law within any area or within the country, then there can be some restrictions on the fundamental. Although all the above fundamental rights were not absolute, and there are reasonable restrictions, and individual reasonable restriction, as I have told you, we will be covering in separate small videos because the video will be too long. Today's our main purpose is to understand what are the fundamental rights from Article 12 to Article 35, excluding Article 31, which was repealed by Article 44th Constitution. Then Article 35, affecting certain fundamental rights. Now, power to make laws to give effect to certain specified fundamental rights shall vest only in the Parliament. Because, for example, we talked about Article 17. So only Parliament can pass the law to enforce this article. For example, we talk about Civil Rights Act, SC/ST Atrocities Act. Okay, Prevention of Atrocities Act. So this can be passed by Parliament only, no state legislature or no other authority. Okay, because fundamental rights should be uniform throughout the country. There cannot be discrimination within the fundamental right. That is the reason that state legislature has not been provided with this power. Now we'll talk about little about Article 31. As I've told you, it was repealed by 44th Constitutional Amendment Act 1978, and now it is not a fundamental right. It is now a constitutional right to property under Article 300A, Part 12 of Indian Constitution. So it was moved from Part 3 to Part 12, from fundamental rights to constitutional right under Article 300A, right to property, and it is still the basic structure, part of basic structure. That means people still have the right to property, citizen, but they cannot move Supreme Court for violation if state is violating that right. Okay. There are some criticisms of the fundamental rights. One is excessive limitation. There are a lot of limitations, as I've spoken a little, but we will be discussing. No social and economic rights, because social and economic rights are covered in DPSPs, and we will be talking about directive principle state policies in separate video. Total, it is a separate chapter. Next chapter will be that it only. But because DPSPs are not legally enforceable, that is why there is no social and economic rights within the fundamental rights. Sometimes there is no clarity, there is a lot of ambiguity, and due to this ambiguity, a lot of cases are going on. For example, I just told you about Sabrimala case, Article 25 versus Article 26. So there is sometimes there is ambiguity. They are not permanent, no non-sacrosanct, as I have talked with. They can be suspended during emergency. And sometimes the remedy is very expensive. Seeking a remedy under Article 32 sometimes is delayed, and the provision of preventive detention under Article 22 is also being criticized by a lot, because there should, sometimes it is arbitrary, and there is no consistent philosophy. There are a lot of philosophical changes. For example, untouchability is there, then SC/ST rights are again there, then minority rights are again there. So there should be uniformity and consistency in the philosophy, that is absent. These are a few criticisms by some people, but apart from that, fundamental rights are being well managed, and it is the base for any citizen, and better than human rights, like to improve the human well-being within the country. The significance of the fundamental rights, it is the bedrock of any democracy, and for liberty it is necessary. To establish a rule of law, it is necessary, and basically to promote the interest of minority and weaker section, Article 17, 29, 30, right? To social equality and justice, it is needed. For example, equality before law, Article 14. Dignity and respect of any individual, Article 21, life and liberty. So these are few significance of fundamental rights. Then there are few rights outside fundamental rights. They are very important. For example, no tax shall be levied or collected except by the authority of law under Article 265, Part 12, right? So no one can be compelled to pay taxes other than by the authority of law. Then no person shall be deprived of the property, Article 300A, we just talked about. And then the trade and commerce throughout the territory shall be free. So you are free to perform the trade and commerce throughout the country. You do not have to pay taxes just because you are having your trade within some territory of India, like custom duty or any other trade. Okay. This was all about basics of fundamental rights. Now we'll look into two questions. One of the implications of equality in society is the absence of privileges. This was a question in 2017. That is what equality means, right? And right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? This was in 2018. Article 14 and the provision under 42nd Constitutional Amendment Act of the Constitution. Article 17 and DPSP of State Policy Part 4. Article 21 and freedom guaranteed in Part 3. Article 24 and provision under 44th Amendment Act of the Constitution. So you can see the Puttaswamy judgment, right to privacy is under Article 21. So C is the correct answer. Okay. Thank you. This was it about today's fundamental right. And keep watching the videos. And you can write your queries to us on info@GyanMimansa.com. And you can join our Telegram channel. Link for all of these will be provided. We will be completing the whole polity in around 60 videos. Today is the 7th video. Thank you.